She walked in at 9:40. The closing was at 10. The escrow officer looked up. The buyer was in the waiting room with his folder. 31 cabins, sold out. $3 million in deposits sitting in escrow. The HOA had been marketing private beach access and exclusive lake frontage as the development's entire selling point. My grandfather recorded the easement in 1962. I'm a licensed title examiner. When I inherited the western Shoreline parcel in 2014, I opened the deed box. The instrument was right there, a 40-foot public access corridor running the full length of Caldwell Lake's western bank. Permanent, unreleased, active. I watched the HOA build the dock, grade the beach, and stake 31 cabin units inside that corridor. I said nothing. I walked the shoreline every October and wrote one line in my log. Easement, active and maintained. 8 years, 8 entries. The closing officer suspended the transaction at 10:03. The judge read entry number 8 and denied the quiet title action. The HOA called on a Friday. Let's kick things off properly. Before we dive in, tell me where you're joining from, and don't forget to hit like and subscribe for more. Nora Crane's grandfather had platted Caldwell Lake in the spring of 1962, a 340-acre natural lake in the county's northern watershed. Spring-fed, clear to 12 feet in the shallows, the kind of water that a man who had grown up beside it understood as something that should be held carefully and released correctly. Arthur Crane had acquired the Caldwell Lake watershed parcel in 1941, 1,200 acres of mixed timber and pasture surrounding the lake on all 4 sides, purchased from an estate sale for the timber value and kept for the water. He had farmed the upland acreage through the 1940s, logged the eastern ridge selectively in the early 1950s, and had watched the county's population grow steadily through that decade, until the calculus of holding 1,200 acres of lakefront land as a working farm no longer made the financial sense it had made in 1941. In 1959, he had hired a survey firm from the county seat, commissioned a boundary survey and a lake bottom survey, and had begun the 3-year process of platting the lake for residential development. The platting had been deliberate. Arthur had not been a man who moved quickly through decisions that would outlive him, and the platting of Caldwell Lake was exactly that kind of decision. A choice about what the lake would be for the next 100 years, made in 1962, recorded in the county deed records, and binding on every owner who came after him. He had divided the eastern and northern shores into 87 residential lots, each with lake frontage, each sized at no less than 3/4 of an acre. He had retained the western shore parcel, a 12-acre strip running the full length of the lake's western bank, in his own name, undivided, unplatted, to be held by the Crane family as a buffer between the residential development and the county road that ran along the western ridge above the lake. The public access corridor had been Arthur's condition for the platting approval, a requirement the County Planning Commission had included in the 1962 plat approval as a public interest provision, and that Arthur had accepted and formalized as a recorded easement rather than a plat condition, because Arthur understood that a recorded easement in the deed records was more durable than a plat notation, and more enforceable than a gentleman's agreement. He had hired the same attorney who had handled the plat to draft the easement instrument, and that instrument had been recorded on April 14, 1962, in the county deed records as a separate document with its own instrument number, referenced in the plat's notes section, and running as an encumbrance against the western shore parcel in every title search conducted from that day forward. The easement instrument was 4 pages. Nora had read it so many times since inheriting the parcel in 2014 that she could recite its operative provisions without looking at the text. But she had the original, the 1962 original, not a copy, the document Arthur had kept in the family's deed box and that had passed to Nora with the parcel. And she kept it in a fireproof file cabinet in her home office, beside her title examination licenses and her grandfather's survey field notes. The easement's operative language was in its second and third paragraphs. The second paragraph defined the corridor, a strip of land 40 feet in width, measured from the ordinary high water mark of Caldwell Lake, inland in a westerly direction, running the full length of the western shore parcel from its northern boundary to its southern boundary, as shown on the attached Exhibit A, being a portion of the land described in Deed Book 47, page 312, County Deed Records. The Exhibit A was a hand-drafted map. The survey firm's work, ink on linen. The 40-foot strip hatched and labeled Public Access Corridor. The lake's ordinary high water mark, shown as a dashed line. The strip's inland boundary, shown as a solid line, 40 feet west of the dashes. The third paragraph stated the corridor's purpose and its restrictions. This easement is granted for the purpose of providing continuous public pedestrian access along the western shoreline of Caldwell Lake. No structure, fence, wall, dock approach, boat ramp, or other obstruction shall be constructed, placed, or maintained within the corridor that would impede pedestrian passage along the shoreline. The easement holder and his successors and assigns shall have the right to enforce this restriction against any person or entity, including the owner of the western shore parcel, and to seek injunctive relief and damages for any violation of this restriction. Arthur had been the easement holder, the Crane family in the instrument's language, and their successors and assigns. The western shore parcel's owner was also Arthur at the time of recording, which gave the easement an unusual character. The same family held both the burden parcel and the enforcement right, a circumstance that had made the easement legally self-contained within the Crane family's ownership for the first 52 years of its existence. When Nora had inherited the parcel in 2014, she had inherited both, the western shore parcel with the 40-foot corridor running through it as a burden, and the easement holder's enforcement rights as an appurtenant benefit. She had read the instrument the week she inherited the parcel, sitting at her grandfather's desk in the ranch house that was now her lake house, and had thought about what Arthur had understood when he drafted it. He had understood that the lake's eastern and northern shores would be developed. He was the one developing them, selling 87 lots, taking the proceeds. He had understood that the western shore, as a retained family parcel, would be the development's visual backdrop and its public amenity. He had created the corridor to ensure that no future owner of the western shore parcel, including his own descendants, could wall off the shoreline from public use. He had constrained his own family's options in 1962 because he believed the lake's public character was worth constraining them for. Nora had agreed with him. She had walked the corridor every year since 2014, the full length of the western shoreline, north boundary to south boundary, the 40-foot strip between the water and the inland boundary line, the same walk the corridor had been designed to make possible. She had noted each walk in her property log with the date and the conditions. April 2014, full corridor walk, shoreline clear, no obstructions. October 2015, corridor walk, lake level normal, east bank visible. Every year from 2014 to 2022, the same notation, the same walk, the use of the easement corridor documented in a dated log that Nora kept with the professional precision of a title examiner, who understood that documented use was the difference between a maintained easement and an abandoned one. The HOA's acquisition of the adjacent parcel had not surprised her. The parcel immediately north of Nora's western shore holding, a 22-acre tract that had been in agricultural use since the 1970s, owned by a family named Dorset, who had farmed it without particular attention to its lake frontage, had gone into foreclosure in early 2019, after the Dorset family's operating loans had come due in a difficult year. The bank had acquired it at the foreclosure sale in March 2019, and had listed it for sale at a price that reflected the lake frontage, without reflecting a careful analysis of what encumbered that frontage. Harborview Lake Community HOA had purchased it in August 2019 for $340,000, a cash purchase, no lender involved at acquisition, the transaction closing in 2 weeks. Curtis Halford had presented the acquisition to the HOA board as a development opportunity. The Western Bank's lake frontage could support short-term rental cabins that would generate revenue for the HOA's operating fund and increase the overall value of Harborview's membership by expanding the community's amenity footprint. The board had voted 6-1 to authorize the acquisition. Nora had read the foreclosure notice in the county legal newspaper when the Dorset parcel went to sale. She had noted in her property log, March 2019, Dorset parcel, 22 acres, north of Western Shore Holding, foreclosure sale, adjacent to my parcel, monitor. She had noted the HOA's acquisition in August 2019, Dorset parcel acquired by Harborview Lake HOA, new adjacent owner, Pull their title commitment when available. She had submitted a public records request to the county recorder's office for the HOA's deed and any associated title documents filed in connection with the acquisition. The deed had been straightforward, a standard warranty deed from the bank to the HOA, the parcel described by meets and bounds, recorded September 4, 2019. No title commitment had been filed with the recorder, the acquisition having been a cash purchase without lender involvement. She had noted, "No lender title commitment at acquisition. Cash purchase. HOA may not have commissioned independent title search. Pull county assessor records and plat map. Confirm relationship between Dorset parcel and 1962 easement corridor." She had pulled the assessor's parcel map and had confirmed what she already knew from the survey. The Dorset parcel's southern boundary abutted the northern boundary of her western shore parcel. The 1962 easement corridor ran along the western bank of Caldwell Lake, her parcel's full length, and the Dorset parcel's western edge ran along the same lakefront, its shoreline directly continuous with hers. The 40-foot corridor's physical character as a shoreline access strip meant that any lakefront development on the Dorset parcel would naturally interface with the corridor's northern end. She had written in her log, "Easement corridor terminus at northern boundary. Dorset parcel's western edge is continuous with corridor. Any dock, beach, or lakefront structure on Dorset parcel's western edge will be adjacent to and potentially encroaching on corridor. Monitor development plans." The development permit application had appeared in the County Planning Commission's public notice register in February 2020. Harborview Lake Community HOA, application for conditional use permit. 31 short-term rental cabin units, western bank parcel, Caldwell Lake. Nora had read the public notice on a Tuesday morning and had driven to the Planning Commission's office that afternoon to read the application file. The application ran to 140 pages, site plan, architectural drawings, drainage study, septic design, traffic analysis, and a project narrative prepared by a planning consultant Curtis had retained. Nora had read the site plan with the specific attention of a title examiner reading a document for encumbrances, looking not at what was shown, but at what was omitted. The site plan showed 31 cabin units arranged in 3 tiers on the western bank parcel, the first tier closest to the lake, the second tier mid-slope, the third tier near the county road. The first tier cabins showed individual deck structures extending toward the lake. The site plan showed a shared beach area at the water's edge, a graded sand beach, a common dock structure extending into the lake, and a series of access paths running from the cabin units to the beach. The beach area, the dock approach, and the access paths were all within the 40-foot corridor, measured from the ordinary high water mark. The site plan had no notation referencing the 1962 easement. The application's title section, the page identifying the parcel's legal description and ownership, listed the HOA as owner with no encumbrances noted. The planning consultant had not referenced the 1962 easement in the project narrative. The application had been prepared as if the 40-foot shoreline corridor did not exist. Nora had read the application from cover to cover and had written in her property log, February 2020, HOA permit application reviewed. 31 cabins, beach area, dock, access paths, all amenity infrastructure within 1962 easement corridor. Application does not reference easement. Planning consultant unaware or not informed. Commission has not flagged encumbrance. Decision, attend hearing, say nothing. The easement will be enforced at the legally optimal moment, which is not the permit stage. She had attended the Planning Commission hearing in April 2020. A Tuesday evening, the commission chambers half full, Curtis Halford presenting the project with the smooth confidence of a retired commercial developer who had presented development projects to planning commissions for 30 years. She had sat in the back row and had not raised her hand during the public comment period. She had listened to Curtis describe the beach amenity, the dock facilities, the private lake access as the project's primary value proposition, and had written in her notepad, Curtis described the beach and dock access as the project's selling point. The beach and dock access are within the 1962 easement corridor. He does not know this. The commission had approved the permit with standard conditions. Construction had begun in the fall of 2020. She had called Thomas Vale in March 2021, 14 months after reading the permit application, 6 months into construction. She had not called him earlier because she had not needed legal advice to watch construction proceed. She had called him when the HOA's marketing materials appeared. The marketing brochure for the Harborview Lakeside Cabins had been mailed to a regional mailing list and posted to the HOA's website in February 2021. A full-color document, professional photography of the partially completed cabins and the cleared beach area, the lake visible in every photograph. The brochure's cover line: exclusive lakefront living, private beach, private dock, private lake access. The interior pages described each cabin unit's lake access as a deeded amenity, language that implied a recorded instrument conveying the beach and dock access rights to each buyer. The pre-sale price range: $180,000 to $240,000 per unit. Nora had read the brochure at her kitchen table overlooking the lake and had noted in her property log, February 2021, HOA marketing brochure received. 31 units, pre-sale pricing $180,000 to $240,000. Beach and dock access described as deeded amenity. Amenity infrastructure within the 1962 corridor. HOA marketing. Lake access. It does not have authority to convey. Time to call Thomas. Thomas Vale had come to the lake house in March 2021. A man in his late 50s with a water rights practice built on exactly the intersection of recorded instruments and physical lake access that this situation represented. Nora had set the 1962 easement instrument, the HOA's marketing brochure, the permit application's site plan, and her property log on the kitchen table, and had said, "Read these in order." He had read them in 40 minutes. He had set the brochure down and had looked at the site plan, and then at the easement instruments Exhibit A, the 1962 hand-drafted map with the 40-foot corridor hatched and labeled. He had said, "The beach area, the dock approach, and every access path shown on the site plan are inside the 40-foot corridor." She had said, "Yes." He had said, "The HOA's title commitment at acquisition, was there one?" She had said, "Cash purchase in 2019, no lender. I requested the title documents from the county recorder. No commitment was filed." He had said, "So the HOA may have purchased a 22-acre lakefront parcel without a title search." She had said, "Or with a title search that missed the 1962 instrument. The instrument is recorded, instrument numbered, referenced in the 1962 plat notes. A competent title search finds it in 20 minutes." He had looked at the easement instrument's operative language, the prohibition on structures, fences, dock approaches, and obstructions within the corridor. He had said, "The dock approach shown on the site plan is a direct violation of the third paragraph's obstruction prohibition. The beach grading is a violation. The access paths may be borderline depending on their construction. Paved paths are structures. Graded dirt paths are arguable." She had said, "The dock approach and the beach grading are unambiguous. That's enough." He had said, "When do you want to enforce?" She had said, "Closing day. The first cabin closing. I want the enforcement moment to be the moment when a buyer is about to transfer $180,000 for a cabin unit whose primary selling point is lake access that the HOA cannot legally convey." Thomas had looked at her for a moment. He had said, "You've been watching this for a year and you want to wait until the first closing." She had said, "The permit stage enforcement would have stopped construction and produced a litigation over whether the easement applied to the Dorset parcel's northern edge. The closing stage enforcement produces a title failure in front of a buyer, a title company, and an escrow officer. And it produces it after the HOA has sold 31 units on the strength of a lake access representation that a recorded instrument from 1962 makes legally impossible to deliver." Thomas had said, "The 31 buyers will have paid deposits." She had said, "The 31 buyers will have been told they were buying lake access. When they discover the lake access depends on an easement that the HOA didn't disclose, they will want the HOA to resolve it, which means the HOA will have 31 buyers pushing from one side and my 1962 instrument pushing from the other. That is a better negotiating position than a permit dispute with a planning commission." He had said, "It is." "When are closings scheduled?" She had said, "The HOA's website shows a projected completion date of spring 2022, with closings beginning in June." He had said, "I'll prepare the encumbrance certificate and the demand package. We'll be ready for June." She had looked out the kitchen window at the lake, the March water gray and still, the western shore's bare willows not yet leafed, the partially completed cabin structures visible on the adjacent parcel's cleared ground to the north. The dock pilings were already set in the lake bottom, within the 40-foot corridor, within the easement her grandfather had recorded on April 14, 1962, the instrument sitting in its fireproof cabinet, 20 feet from where she was standing. Arthur Crane had recorded the easement 60 years ago and had kept it in the family deed box, and it had passed to Nora with the parcel and the property log and the survey field notes and everything else Arthur had understood was worth keeping correctly. She had walked the corridor in October 2021, the annual walk, north to south, the full 40-foot strip, the same walk she had made every year since 2014. The dock pilings had been set by then, the beach area graded, the access paths cleared. She had walked past all of it on the corridor's inland edge, within the 40-foot strip, the public access the easement guaranteed undisturbed, despite everything the HOA had built alongside it. She had written in her property log, October 2021, corridor walk, full length, north to south, dock piling set within corridor, clear obstruction violation, beach grading within corridor, access paths within corridor, easement, active and maintained. Closing day, spring 2022. She had put the log away and had gone inside. 60 years was a long time to hold a recorded instrument. June was not far away. Thomas Vail had prepared his easement analysis in April 2021, a 22-page memorandum, structured in the format he used for litigation-bound title disputes. Legal description analysis first, instrument language second, physical encroachment third, enforcement rights fourth, and opposing theory assessment last. He had sent Nora a draft in the first week of April with a cover note. Read the opposing theory section carefully. It is the section the HOA's attorney will write when this surfaces, and I want you to assess my counter-analysis before we finalize. She had read the memorandum over a weekend and had returned it with margin notes in 3 colors, the same system she had used for 35 years of title examination work: black for confirmation, red for correction, blue for questions. The red notes were few, the blue notes were 4, the black notes ran through the legal description section and the instrument language section without interruption. The annotations of a title examiner reading analysis that confirmed what she had already concluded and finding it sound. Thomas had incorporated the margin notes into the final memorandum and had filed it in the case folder, the folder that now held the 1962 instrument, the Exhibit A map, the HOA's permit application site plan, the marketing brochure, Nora's property log extracts, and the county recorder's confirmation that no title commitment had been filed in connection with the HOA's 2019 cash acquisition. The memorandum had become the legal foundation for everything that followed. The legal description analysis had been Thomas's first task, and the most technically demanding section of the memorandum, the work of confirming that the 1962 easements described corridor matched the physical ground in a way that was legally precise and litigation-proof. Arthur Crane had described the corridor in 2 ways in the 1962 instrument: by narrative description in the operative paragraph, and by the Exhibit A map. The narrative description defined the corridor as a strip of land 40 feet in width, measured from the ordinary high water mark of Caldwell Lake inland in a westerly direction, running the full length of the western shore parcel. The Exhibit A map showed the same strip as a hatched zone between the lake's ordinary high water mark and a line drawn parallel to it 40 feet inland. Thomas had engaged a licensed surveyor to set the ordinary high water mark from the lake's documented gauge records and to survey the corridor's inland boundary at 40 feet. The same methodology Arthur's original survey firm had used in 1962, applied to the current ground conditions. The survey had confirmed that the ordinary high water mark had moved less than 2 feet in 60 years. The lake's level stable within a narrow range due to the spring-fed inflows and the county's downstream weir control. The corridor's inland boundary at 40 feet remained within 3 feet of the 1962 Exhibit A line in every measurement taken along the western shore. The physical confirmation had been necessary because Thomas had anticipated the HOA's first counter-argument, that the ordinary high water mark had shifted since 1962, changing the corridor's location and potentially reducing its overlap with the development's amenity infrastructure. The survey had closed that argument before it could be made. The corridor's position was confirmed. The overlap with the HOA's beach area, dock approach, and access paths was documented to the inch, and the survey plat showing the encroachments had been prepared and certified by a licensed professional whose work would stand in court. Thomas had written in the legal description section, "The 1962 easement corridor is precisely located, surveyable to current ground conditions, and its inland boundary at 40 feet from the ordinary high water mark encompasses all of the amenity infrastructure constructed by the HOA within the Western Bank parcel's lakefront zone." The legal description is unambiguous. The Exhibit A map is consistent with the narrative description, and the surveyor's 2021 fieldwork confirms the corridor's current location without material deviation from the 1962 instrument. The instrument language section had been the memorandum's analytical core, Thomas working through the operative paragraphs with the attention of an attorney who knew the HOA's attorney would read the same language and needed to have answered every available argument before it was made. The second paragraph's definition of the corridor was clean. 40 feet from the ordinary high water mark, full length of the western shore parcel, Exhibit A for reference. No ambiguity in the description, no qualifying language that narrowed the corridor's scope, no temporal limitation on the easement's duration. The instrument was a permanent recorded easement with no sunset provision and no reversion clause. It ran with the land indefinitely. The third paragraph's restriction language was the section Thomas had read most carefully. He had broken it into its component prohibitions and had analyzed each against the HOA's constructed amenity infrastructure. No structure. The dock approach pilings were structures, embedded concrete and steel extending from the land surface into the lake bottom, permanent, load-bearing. The shared beach pavilion shown on the construction drawings was a structure, a roofed open-air shelter with concrete footings. The access paths, if paved, were structures. The prohibition on structures within the corridor was violated by the dock approach pilings and the beach pavilion at minimum. No fence. Not applicable to the current construction. No fence had been built within the corridor. No wall. Not applicable. No dock approach. The instrument named dock approaches specifically. Arthur had anticipated that lakefront development would involve dock construction and had named the dock approach as a prohibited encroachment by category. The HOA's dock approach, the piled structure running from the beach area to the dock platform extending into the lake, was precisely the category of obstruction Arthur had named. This was not an inference or an analogy. The instrument prohibited dock approaches within the corridor, and the HOA had built one. No boat ramp. Not applicable. No boat ramp had been constructed. No other obstruction that would impede pedestrian passage along the shoreline. The beach grading, the clearing and leveling of the natural shoreline vegetation within the corridor to create the manufactured sand beach, had altered the shoreline's character in a way that, depending on its physical effect on pedestrian passage, could constitute an obstruction under this provision. Thomas had noted it as a secondary violation, subsidiary to the dock approach and pavilion violations, which were categorical and unambiguous. The enforcement rights paragraph had been the section Thomas found most significant from a litigation posture standpoint. Arthur had written, "The easement holder and his successors and assigns shall have the right to enforce this restriction against any person or entity, including the owner of the Western Shore parcel, and to seek injunctive relief and damages for any violation of this restriction." The phrase, "including the owner of the Western Shore parcel," was the provision that made the easement self-enforcing within the Crane family's own holding. Arthur had not wanted any future Crane family member to be able to argue that the easement didn't apply to family-owned land. But the phrase, "any person or entity," was the provision that applied to the HOA. The enforcement right ran against any party whose actions violated the corridor's restrictions, regardless of whether that party owned the Western Shore parcel or the adjacent Dorset parcel or any other land. The HOA had built structures within the corridor. The HOA was a person or entity. The enforcement right applied. Thomas had written in the instrument language section, "The 1962 easement instrument prohibits, by specific category, the construction of a dock approach within the 40-foot corridor. The HOA has constructed a dock approach within the 40-foot corridor. The violation is categorical. The instrument names the exact type of structure the HOA built in the exact location the instrument prohibits. This is not a case requiring interpretive analysis of broad restriction language. The instrument anticipated this construction and prohibited it. The title commitment failure section had required Thomas to reconstruct what a competent title examiner would have found in 2019, had one been engaged to examine the Dorset parcel's title before the HOA's acquisition. The 1962 easement instrument was recorded in the county deed records on April 14, 1962, assigned instrument number 1962-04-0847. It was indexed in the county's Grantor-Grantee Index under Arthur Crane as Grantor. The index entry reading, Crane, Arthur H. Easement, Public Access Corridor, Western Shore Parcel, Caldwell Lake. Instrument 1962-04-0847. The instrument was also cross-referenced in the 1962 Plat's Notes section, Plat Book 12, page 47, with the notation, Public Access Corridor Easement recorded separately. See Instrument 1962-04-0847. A title search of the Dorset parcel in 2019 would have begun with the parcel's ownership chain and proceeded to the encumbrance search, the examination of every recorded instrument affecting the parcel or its appurtenant area. The Dorset parcel's western boundary abutted the ordinary high water mark of Caldwell Lake. Any competent title examiner searching a lakefront parcel would examine the adjacent parcel's encumbrance record for easements running along the shoreline, standard practice for lake properties, where shoreline access easements, riparian rights reservations, and public trust doctrines frequently burden the waterfront boundary. The Western Shore parcel, Nora's parcel, was the adjacent parcel to the Dorset parcel's south. Its encumbrance record showed instrument 1962-04-0847 in the first search page. The 1962 Plat, governing the lake's overall development framework, referenced the same instrument in its notes section. A title examiner who pulled the Caldwell Lake Plat, which governed the lake's residential development, and which any examiner searching a Caldwell Lake parcel would pull as a matter of standard practice, would have seen the cross-reference on the first page of the Plat notes. Thomas had written, the 1962 easement instrument was findable in 20 minutes by any title examiner applying standard practice to a Caldwell Lake lakefront parcel search in 2019. The instrument's existence was disclosed in two independent locations in the county's public records, the Grantor-Grantee Index and the 1962 Plat Notes. The HOA's cash acquisition without a lender required title commitment does not explain the failure to find the instrument. A purchaser's title search, even without a lender's requirement, should have found it. The failure to find the instrument was either a failure to conduct a title search or a failure to conduct it competently. The consequence for the 31 cabin buyers' title insurance policies had been the section Thomas had drafted most carefully, because those buyers were not the HOA and were not responsible for the title search failure, and the posture toward them in any enforcement proceeding needed to reflect that distinction. Each of the 31 pre-sale buyers had entered into a purchase agreement that included a title insurance commitment. The HOA's cabin development, unlike the 2019 cash acquisition, was being financed by individual buyers through lenders, and lenders required title insurance. The title insurance had been issued by a national underwriter through a local title company. The title company had conducted a title search in connection with the commitment issuance, a search that had also failed to find the 1962 easement. Thomas had obtained one of the buyer's title commitment documents through a public records request and had confirmed the failure. The commitment's Schedule B, the section listing known encumbrances and exceptions from coverage, did not list Instrument 1962-04-0847. The 1962 easement had not been disclosed to any of the 31 buyers in their title commitments. Each buyer had been issued a policy that insured their title against encumbrances not listed in Schedule B, and the 1962 easement was not listed. The buyers had title insurance policies that, by their terms, insured against exactly the encumbrance that affected their properties. This meant that when the easement surfaced, the title insurance underwriter would have exposure on 31 policies, not for the easement's existence, which was a matter of public record and arguably should have been found, but for the failure to disclose it in Schedule B, which was the underwriter's obligation. Thomas had noted, the title insurance underwriter's exposure on the 31 cabin buyers' policies will make the underwriter a party with strong financial incentive to participate in any settlement that resolves the easement encumbrance and eliminates the policy's undisclosed encumbrance claims. The underwriter's participation in settlement funding is a significant source of resolution capital that does not require the HOA to bear the full cost of its title search failure. The physical encroachment section had been built on the 2021 survey, the survey plat showing the corridor's current location and the HOA's amenity infrastructure plotted against it, the encroachments measured and labeled with the precision of a licensed professional document. The dock approach, entirely within the corridor. The approach structure ran from a point 38 feet from the ordinary high water mark, 2 feet inside the corridor's inland boundary, outward across the beach area and into the lake. Every foot of the dock approach's landside portion was within the 40-foot strip. The beach pavilion, partially within the corridor. The pavilion's lakeside posts were at 36 feet from the ordinary high water mark. The pavilion's inland posts were at 44 feet, 4 feet outside the corridor. The pavilion straddled the corridor's inland boundary, its lakeside half within the prohibited zone, and its inland half outside it. The access paths. 3 of the 7 paths shown on the site plan were entirely within the corridor. The remaining 4 crossed the corridor's inland boundary at angles, with portions inside and portions outside the strip. The sand beach area. The graded and imported sand covered the full shoreline zone from the ordinary high water mark to approximately 45 feet inland, 5 feet beyond the corridor's boundary at its deepest inland point. The beach grading and sand importation had physically altered the corridor's ground surface across its full width. Thomas had written in the physical encroachment section, the HOA's lakefront amenity infrastructure encroaches on the 1962 easement corridor in 4 categories: the dock approach, the beach pavilion, 3 access paths, and the beach grading. The dock approach violation is categorical under the instrument's specific prohibition. The remaining violations are structural obstructions and surface alterations within the protected corridor. Together, the encroachments affect the corridor's full width at the point of maximum intrusion and establish that the HOA's cabin development was constructed without reference to the easement's restrictions. The enforcement demand had taken Thomas 2 weeks to draft after the memorandum was finalized. A 17-page letter addressed to Curtis Halford as HOA president and to the HOA's registered agent, with a copy to Brenda Polk as HOA counsel. The letter presented the analysis in condensed form. The 1962 instrument, the corridor's location, the physical encroachments, the instrument's specific prohibition on dock approaches, the enforcement rights provision. The demand set out 3 requirements: removal of all structures within the corridor within 180 days, a recorded acknowledgement of the easement's validity and the HOA's obligation to maintain the corridor free of obstructions, and compensation for the construction period's encroachment. Thomas had drafted the demand's final paragraph and had sent it to Nora for review on a Thursday afternoon. She had read it, had noted one correction in the penalty section, and had called him. She had said, "The demand is ready, except for one instruction." He had said, "The timing." She had said, "Hold it. Don't send it until the first closing date is confirmed. I want the closing on the calendar and the buyer identified before the letter goes out." He had said, "You want the demand to arrive after the closings are scheduled, but before the first one completes." She had said, "I want the demand in Curtis Halford's hands on the morning of the first scheduled closing, not a week before, the morning of. I want him reading it at the same time his escrow officer is opening the closing file." Thomas had said, "That requires knowing when the first closing is scheduled." She had said, "The HOA's website has a completion timeline. When they post the closing schedule, I'll call you. Keep the demand ready." She had set the phone down and had looked out the window at the lake, the April afternoon light on the water, the cabin structures visible to the north, the dock piling standing in the shallows within her grandfather's corridor. The demand was 17 pages, ready to send, sitting in Thomas Vale's case folder, with the 1962 instrument and the survey plat, and the title commitment failure analysis, and everything else Arthur Crane's April 14, 1962 recording had made possible. Arthur had recorded the instrument 62 years ago, and had kept the original in the family deed box, and Nora had kept it in the fireproof cabinet, and Thomas Vale had cited it in 17 pages of demand letter that was going to arrive on the morning of the first closing. The HOA's website showed a projected completion date of April 2022 and a closing schedule beginning in June. She opened her property log and wrote, April 2021, demand letter prepared, held pending closing schedule. Instrument, ready. Survey, filed. Title commitment failure, documented. Closing day, June 2022. She closed the log. June was 14 months away. She had waited 62 years already, in the sense that mattered. The instrument had been waiting since 1962 for the moment when someone built a dock approach inside its 40-foot corridor and tried to sell it to 31 buyers as a private lake amenity. 14 months was nothing. The HOA's website had posted the closing schedule on a Thursday afternoon in late April 2022. A page titled Harborview Lakeside Cabins, Closing Information, listing 31 units with their assigned closing dates spread across June, July, and August. The first closing scheduled for June 7th at 10 a.m. at the Caldwell County Title Company's office on Main Street. Nora had read the page that evening and had called Thomas. She had said, June 7th, 10 a.m., Caldwell County Title. He had said, I'll send the demand letter tomorrow morning, certified mail to Curtis Halford and Brenda Polk, delivery by Monday. She had said, send it. And Thomas, I want to be at the closing. He had said, as the easement holder, you have standing to appear. I'll be there as your counsel. Will arrive before 10. She had set the phone down and had opened her property log. April 28th, 2022, closing schedule posted. Unit 1 closes June 7th, 10 a.m., Caldwell County Title. Demand letter, sending April 29th. Appearance, June 7th, 9:45 a.m. She had closed the log and had gone to the fireproof cabinet and had taken out the 1962 easement instrument, the original, not the copy she had provided to Thomas for the case folder, the actual document Arthur Crane had signed in April 1962 and kept in the family deed box for 52 years before Nora had inherited it. She had set it on the kitchen table under the lamp and had read it one more time. The operative paragraphs, the legal description, the prohibition language, the enforcement rights provision. The ink was still clear on the 1962 bond paper, Harold's signature at the bottom still legible in the same blue ballpoint he had used for every document of consequence in his adult life. She had put it back in the cabinet and had gone to bed. The demand letter had been delivered on Monday, May 2nd, certified mail, return receipt, Curtis Halford signing the green card at the HOA management office at 9:15 a.m. Brenda Polk had received her copy at her law office at 10:40. Curtis had read the first 2 pages and had called Brenda immediately. Brenda had said, I haven't read mine yet. Give me an hour. She had called him back at noon. She had said, the 1962 easement instrument is real. I pulled it from the county recorder's online portal while I was reading the letter. It's recorded, it's indexed, it's in the plat notes. The title company missed it. Curtis had said, can we fight it? She had said, the abandonment theory is the primary argument. The easement was created in 1962 for public pedestrian access. If we can demonstrate that the public access purpose has been abandoned, that no one has used the corridor for public pedestrian access in a meaningful way for decades, we have an argument that the easement's purpose has lapsed. Curtis had said, has anyone used it? Brenda had been quiet for a moment. She had said, the demand letter says Nora Crane has been using it annually since 2014 and has documentation. I don't know what the public use history was before 2014. We'd need to investigate. Curtis had said, investigate it. And call the title company. They missed this in the commitment, and they need to know it's surfacing at closing. He had called the title company himself at 1 p.m. The local branch manager, a woman named Sandra Reeve, who had managed the office for 11 years. He had said, Your commitment for the Harborview cabin units missed a 1962 easement. The easement holder has sent a demand letter and plans to appear at the June 7th closing. Sandra Reeve had pulled the commitment file and had been quiet for 40 seconds. She had said, "I'll call our underwriters regional counsel this afternoon." Curtis had said, "You do that." He had spent the rest of the afternoon reading the demand letter's 17 pages with the attention he had not given the first 2 pages. And by the time he reached the physical encroachment section, the survey plat coordinates, the dock approach measurement at 38 feet from the ordinary high water mark, the specific citation of the instrument's dock approach prohibition, he had understood that the gap between where he had been an hour ago and where the demand letter said he was could not be closed by an afternoon's worth of phone calls. He had called Brenda back at 4:30. He had said, "The dock approach. The instrument names dock approaches specifically." She had said, "I know. I read that section." He had said, "Is there an argument?" She had said, "The abandonment theory covers everything in the corridor, including the dock approach. If we establish abandonment, the instrument is extinguished and the specific prohibition becomes moot." He had said, "And if we don't establish abandonment?" She had been quiet. She had said, "Then the dock approach is a categorical violation, and we are in a difficult position on injunctive relief." Curtis had not said anything for a moment. He had said, "June 7th is 5 weeks away." Brenda had said, "I know. I'll have a full assessment to you by end of week. Don't communicate with Nora Crane or Thomas Vale directly before we talk." Thomas had prepared the encumbrance certificate in the 2 weeks before the June 7th closing, a formal document executed by Nora as licensed title examiner, certifying that parcel 44-3301-002, the Western Shore parcel, carried instrument 1962-04-0847 as a recorded encumbrance in the county deed records as of the certificate's execution date, and that the encumbrance had not been released, modified, or extinguished by any recorded instrument as of that date. The certificate ran to 3 pages, cited the instrument's recording information, summarized its operative provisions, and included a certified copy of the instrument attached as an exhibit. It was not a legal brief. It was a title examiner's professional certification of a recorded fact, the kind of document a closing officer was trained to take seriously because it came from a licensed professional whose certification was a representation subject to professional liability. Thomas had also prepared a 1-page summary of the physical encroachments, the survey data in table form, each encroachment listed by category with its distance from the ordinary high water mark, and a copy of the 2021 survey plat showing the corridor and the HOA's amenity infrastructure plotted against it. He had organized the closing day package, the 1962 instrument original, the encumbrance certificate, the encroachment summary, the survey plat, and a 2-page legal memorandum summarizing the easement holder's position and the title commitment's failure to disclose the encumbrance. The package was assembled in a manila folder with a cover sheet listing its contents in order. He had called Nora on the evening of June 6th to confirm the plan. She had said, "I'll drive separately. Meet you at Caldwell County Title at 9:40. He had said, "The closing officer will be Sandra Reeves' branch, probably a closer named either Davis or Hendricks, based on the branch's staff list. Whoever it is, they will have seen Curtis's call to Sandra and may have been briefed on the situation. Or they may not have been. Either way, our presentation is the same. We present the encumbrance certificate. We explain the title commitment's failure to disclose, and we ask the closer to suspend the transaction pending resolution." She had said, "Do we identify ourselves before the closing starts, or do we wait for the closer to open the file?" He had said, "We identify ourselves when we arrive. We are not ambushing anyone. We are an easement holder, and her counsel appearing at a closing where the title commitment failed to disclose our client's recorded encumbrance. That is a legitimate appearance with a legitimate purpose. We tell the receptionist who we are and ask to speak with the closing officer before the transaction opens." She had said 9:40. He had said 9:40. The Caldwell County Title Company office was a single-story building 2 blocks from the county courthouse, a waiting room with 4 chairs and a reception desk, 2 closing rooms off a short hallway, the branch manager's office at the end. Nora had arrived at 9:38, Thomas at 9:41, both of them in the parking lot for a moment before going in together. The receptionist had looked up when they entered. Thomas had said, "Thomas Vale and Nora Crane. We're here regarding the 10 o'clock closing for Harborview Lakeside Cabins, Unit 1. We represent the holder of a recorded easement affecting the subject property that was not disclosed in the title commitment. We'd like to speak with the closing officer before the transaction opens." The receptionist had processed this for a moment and had said, "Let me get Ms. Hendricks." The closing officer had been a woman named Patricia Hendricks, 12 years with the branch, the senior closer, the one Sandra Reeve had assigned to the Harborview units after Curtis's call, because Sandra had wanted her most experienced person in the room. Patricia had come out of the hallway and had looked at Thomas and Nora with the measured assessment of a professional who had been briefed on the situation and had not been looking forward to 10 a.m. She had said, "Mr. Vale, Miss Crane, come back." She had taken them to the second closing room, the larger one, with a rectangular table that seated 6. She had set the Unit 1 closing file on the table and had said, "The buyer arrives at 10. I've been informed there's an easement question. Walk me through what you have before he gets here." Thomas had set the manila folder on the table and had gone through the contents in order. The 1962 instrument first, the original, the ink clear, Arthur Crane's signature at the bottom. He had set it in front of Patricia and had said, "Instrument number 1, 962-04-0847, recorded April 14th, 1962, County Deed Records. A 40-foot public access corridor easement running along the full length of the western shoreline of Caldwell Lake, adjacent to the subject parcel." Patricia had looked at the instrument and had turned to the operative paragraph. She had read the dock approach prohibition and had set the document down without comment, the expression of a closer who had found the specific language she had been hoping not to find. Thomas had set the encumbrance certificate in front of her next, Nora's professional certification, the instrument number, the summary of operative provisions, the certified copy attached. He had said, "Ms. Crane is a licensed title examiner. The certificate is her professional certification that this instrument appears in the county deed records as an active encumbrance on the western shore parcel, unreleased and unmodified, as of the certificate's execution date." He had set the encroachment summary and the survey plat next. He had said, "The survey plat shows the 40-foot corridor's current location and the HOA's lakefront amenity infrastructure plotted against it. The dock approach shown in the Unit 1 marketing materials, the dock access the buyer purchased as a primary amenity, is constructed within the corridor. The instrument specifically prohibits dock approaches within the corridor." Patricia had looked at the survey plat for 30 seconds. She had said, "The title commitment Schedule B doesn't list this instrument." Thomas had said, "Correct. The commitment failed to disclose a recorded encumbrance affecting the property's primary access amenity. The buyer has a title insurance policy that insured against undisclosed encumbrances. This encumbrance was undisclosed." Patricia had said, "I need to call Sandra." She had stepped out of the room. Thomas and Nora had sat at the table. Through the closing room's window, they could see the parking lot. A car had pulled in at 9:58, a man in his 40s getting out with a folder under his arm. The Unit 1 buyer arriving for a 10 a.m. closing that was not going to proceed as he had planned. Patricia had come back at 10:03. She had said, "Sandra is calling the underwriter's regional counsel. I'm going to need to ask Mr. Donovan, the buyer, to wait while we sort out the title issue. This may take some time." She had gone to the waiting room. Through the doorway, Nora had heard Patricia explaining to the buyer that there was a title matter requiring resolution before the closing could proceed, and asking him to wait. The buyer's voice had been even, a question about how long, and Patricia's answer had been careful. Curtis Halford had arrived at 10:17. Nobody had called him, but the management company's coordinator had been monitoring the HOA's email and had seen Sandra Reeves' message to Curtis about the easement question surfacing at closing, and had forwarded it with a flag. Curtis had driven from his house, 15 minutes, and had walked in with the energy of a man who believed his presence at a problem solved the problem. Patricia had shown him to the closing room and had made the introduction without editorializing. Thomas Vale, easement holders counsel. Nora Crane, easement holder. Curtis Halford, HOA president. Curtis had looked at the documents on the table, the 1962 instrument, the encumbrance certificate, the survey plat, and had said, "This easement is historical. It was created in 1962 for public pedestrian access to a lake that had no development on it at the time. It has not been used for public pedestrian access in any meaningful way for decades. It has been abandoned by non-use and is unenforceable." Thomas had said, "The easement has been continuously recorded in the county deed records since April 14, 1962. It has not been released, modified, or extinguished by any recorded instrument. Non-use does not extinguish a recorded easement under state law. Easement abandonment requires affirmative acts by the easement holder, demonstrating a clear intent to permanently relinquish the right. The easement holder's inaction does not constitute abandonment." Curtis had said, 60 years of non-use by the public is a clear demonstration that the easement's purpose has lapsed. Thomas had said, "Ms. Crane has used the easement corridor for pedestrian access along the western shoreline every year since she inherited the parcel in 2014. She has documented each use in a dated property log. The easement has been actively used within the past 12 months. The non-use argument does not apply." He had set Nora's property log extracts on the table. 8 years of annual corridor walk entries, each dated, each noting the conditions and the full length of the walk. Curtis had looked at the pages without picking them up. Nora had said, for the first time since entering the room, "The public access corridor was created by my grandfather in 1962 as a condition of the Caldwell Lake Plat, the plat that established the 87 lots on Harborview's eastern and northern shores. Your HOA's member properties exist because Arthur Crane platted this lake and recorded this instrument as part of the same transaction. The easement and the plat are 60 years old, and they were recorded together." Curtis had looked at her. He had said, "The development is nearly complete. 31 buyers have signed purchase agreements. Closings are scheduled through August." Nora had said, "I know." Curtis had said, "You've known about this since construction started." She had said, "I've known about the 1962 instrument since I inherited the parcel in 2014. I've known about the encroachment since I read your permit application in February 2020. Yes." The room had been quiet for a moment. Curtis had said, "Why wait until today?" She had said, "Because today is when the legal position is clearest. The title commitment failed to disclose a recorded encumbrance. A buyer is in your waiting room who paid a deposit on a cabin unit whose primary amenity depends on lake access running through my grandfather's corridor. The closing cannot proceed until the encumbrance is resolved. That is a more legible situation than a permit dispute with a planning commission 2 years ago." Curtis had looked at Thomas. He had said, "We will assert the abandonment theory in court." Thomas had said, "You're welcome to do that. The closing cannot proceed today regardless of what theory you intend to assert. The title commitment has an undisclosed encumbrance. Patricia Hendricks cannot close this transaction with a known unresolved encumbrance in the file." Patricia had been standing in the doorway. She had said, "That's correct. I can't close this transaction today. I've suspended it pending the underwriter's guidance and resolution of the encumbrance question." Curtis had looked at Patricia, then at Thomas, then at the survey plat showing the 40-foot corridor and the dock approach pilings measured at 38 feet from the ordinary high water mark. He had said, "I need to call my attorney." Thomas had said, "Brenda Polk has had the demand letter since May 2nd. She's had 5 weeks." Curtis had not answered. He had picked up his phone and had walked into the hallway. Patricia had looked at Thomas and Nora and had said, "I'll let Mr. Donovan know the closing is suspended for today. He'll want to speak with his own attorney." Thomas had said, "That's appropriate. He has a title insurance policy. His insurer has an obligation to him on the undisclosed encumbrance." Patricia had nodded and had gone back to the waiting room. Nora had looked at the documents on the table, the 1962 instrument lying open to Arthur's signature, the encumbrance certificate beside it, the survey plat with the corridor hatched and the dock approach pilings marked at 38 feet. Through the window she could see Curtis in the parking lot, with his phone to his ear, pacing between the cars. The first closing had failed. 30 more were scheduled through August. She had picked up the 1962 instrument and had put it back in the manila folder. She had looked at Arthur's signature one more time before closing the folder. The careful blue ballpoint, the April 1962 date, the man who had platted this lake and recorded this instrument and kept the original in a deed box for the people who came after him to use when the time was right. The time had been right at 10 a.m. on June 7, 2022. She closed the folder and waited for Thomas to finish his notes. Brenda Polk had filed the abandonment brief in County District Court on June 21st, 2 weeks after the first closing failed. The HOA's legal response to a situation that had suspended all 31 cabin closings and left the title company, the underwriter's regional counsel, and 31 buyers in varying states of financial anxiety, waiting for a resolution that Curtis Halford had decided would come through litigation rather than negotiation. The brief was 31 pages, the length reflecting Brenda's awareness that the abandonment theory required substantial development to survive a motion to dismiss. The argument constructed from every available source of legal support, with the care of an attorney who knew the foundation was not solid, and was building the structure as carefully as the foundation allowed. The abandonment theory's legal framework was Brenda's first section, 8 pages setting out the doctrine as it existed in the state's case law, the treatise citations, the statutory provisions. Easement abandonment was an established doctrine. A recorded easement could be extinguished by abandonment if the easement holder took affirmative acts demonstrating a clear and unequivocal intent to permanently relinquish the easement right. The doctrine was recognized. The standard was the problem. Brenda had written, "While the state's abandonment doctrine requires affirmative acts of relinquishment, courts have recognized that the totality of circumstances surrounding an easement's non-use, including the duration of non-use, the changed conditions of the surrounding area, and the original purpose's practical obsolescence, may collectively constitute constructive abandonment, even in the absence of a single decisive affirmative act." She had cited 4 cases, the strongest of which was a 1987 appellate decision involving a railroad right-of-way that had been unused for 40 years, and whose original transportation purpose had been rendered functionally obsolete by the abandonment of the rail line. The court had found abandonment on those facts. The railroad case was the best case in her brief, and it was distinguishable on 3 grounds that Thomas had identified before Brenda filed it, because he had researched the same case law and had known it was the argument she would make. The factual argument occupied Brenda's second section, 12 pages of historical analysis, attempting to establish the minimal public use of the 1962 corridor across 60 years. She had interviewed 4 long-term Caldwell Lake residents, and had obtained sworn declarations from 3 of them, stating that they had lived on the lake for between 20 and 40 years, and had never observed members of the public walking the western shoreline corridor. She had obtained the County Parks Department's recreational access records, showing no designated public trail along the western shore at any point in the county's trail system. She had obtained aerial photographs from 1975, 1988, 2003, and 2014, showing the western shoreline's vegetation, the willow and sedge growth indicating minimal human foot traffic over the documented periods. It was the strongest factual record she could build, and Thomas had read it with professional respect for the effort before writing his response. Thomas's rebuttal had been filed July 12th, 24 pages, structured as a direct response to each of Brenda's arguments. The counter-analysis organized so that a judge reading both briefs in sequence would find Thomas's response positioned precisely against each of Brenda's points. The legal framework counter-argument was Thomas's most important section, because it addressed the doctrine at its foundation. He had written, "The abandonment doctrine requires affirmative acts by the easement holder, demonstrating intent to permanently relinquish. This standard is not satisfied by non-use alone, however extended, and is not satisfied by the constructive abandonment theory the HOA advances. The constructive abandonment theory, derived from the 1987 railroad right-of-way decision, applies to easements whose original purpose has been rendered permanently and completely obsolete by external circumstances beyond the easement holder's control. The Caldwell Lake Public Access Corridor's purpose, public pedestrian access along the western shoreline of a 340-acre lake, has not been rendered obsolete. The lake exists, the shoreline exists, the corridor exists. Public pedestrian access along a natural lakeshore is not a purpose that becomes obsolete with the passage of time." He had distinguished the railroad case on 3 grounds. The railroad easement's purpose depended on active rail service that had permanently ceased through the rail company's own decision, an affirmative act by the easement holder. The public access corridor's purpose depended on no external infrastructure that had ceased operation, and the Railroad Cases Court had specifically noted that the rail company's filing of abandonment notices with the Interstate Commerce Commission was the decisive affirmative act, not the non-use alone. Thomas had written, "The HOA's abandonment theory removes the affirmative act requirement and replaces it with a duration of non-use standard. No state court has adopted this standard. The 1987 decision did not adopt it. The Railroad Cases Affirmative Act was the ICC filing, not the non-use, and the non-use was cited as corroborating circumstance, not as the legal basis for abandonment. The HOA's theory asks this court to extinguish a recorded easement on the basis of non-use alone, contrary to 60 years of consistent state case law requiring affirmative relinquishment." The factual counter-argument had three parts: Nora's use record, the 2018 Planning Commission letter, and the 2021 notice letter to Curtis. Nora's use record was in the property log extracts Thomas had attached as Exhibit C. 8 years of annual corridor walk entries, 2014 through 2021, each dated, each noting the walk's conditions, each in Nora's hand in the same property log she had maintained since inheriting the parcel. The entries were not elaborate. April 2014, corridor walk, full length north to south, shoreline clear. October 2015, corridor walk, full length, lake at normal level. 8 consecutive years of documented use, each within the easement's purpose, pedestrian access along the western shoreline, each recorded by the easement holder in a contemporaneous log. Thomas had written, "The easement holder has documented annual use of the corridor for pedestrian access along the western shoreline in every year of her ownership from 2014 to 2021. This use is contemporaneously recorded in a property log, maintained with the consistency of a licensed professional who understood the legal significance of documented use." The HOA's abandonment theory requires the court to find that an easement holder who has used the easement annually for 8 years has abandoned it. This finding is not available under any legal standard this court is authorized to apply. The 2018 Planning Commission letter was Exhibit D, a letter Nora had submitted to the County Planning Commission in March 2018 in response to a routine notice about a proposed minor subdivision on a parcel at the lake's northern end, a subdivision that had no relationship to the HOA's development, but that had triggered Nora's standard practice of referencing the 1962 easement in any county land use proceeding involving the Caldwell Lake watershed. The letter's relevant paragraph read, "I am writing to note for the Commission's record that Caldwell Lake's western shoreline is subject to a recorded public access corridor easement, Instrument Number 1-962-04-0847, which should be considered in any land use review affecting the lake's western bank or adjacent parcels." The letter was dated March 14, 2018, 4 years before the closing dispute, 2 years before the HOA's permit application, filed in the county's public planning records, where any competent review of the Caldwell Lake area would have found it. Thomas had written, "In March 2018, the easement holder submitted a letter to the County Planning Commission specifically referencing Instrument 1-962-04-0847 and its applicability to Caldwell Lake land use proceedings. This letter appears in the county's public planning records. The HOA submitted its development permit application to the same Planning Commission in February 2020 without referencing the easement. The easement holder's 2018 letter was available in the same public records the HOA's planning consultant reviewed in preparing the 2020 permit application. The constructive abandonment theory requires changed conditions and practical obsolescence. The 2018 letter establishes that the easement holder affirmatively asserted the easement's relevance to Caldwell Lake land use proceedings 2 years before the HOA's development began. The 2021 notice letter was Exhibit E, and it was the document that had shifted Thomas's assessment of the litigation's likely outcome from cautiously favorable to definitively favorable the moment Nora had mentioned it in their first meeting. She had sent it in August 2021, 14 months into the HOA's construction, 8 months before the first scheduled closing. It was a 2-page letter on plain stationery, addressed to Curtis Halford at the HOA's management office address. The letter's first paragraph identified Nora as the owner of the Western Shore parcel and the holder of easement instrument 1962-04-0847. The second paragraph described the corridor's location and the instrument's prohibition on structures and dock approaches within the 40-foot strip. The third paragraph stated, "I have observed construction activity on the adjacent Western Bank parcel that appears to include structures within the 40-foot easement corridor, including what appears to be a dock approach structure. I am writing to bring this to your attention and to note that any structure within the easement corridor is subject to the instrument's restriction provisions." The fourth paragraph provided Thomas Vale's contact information and invited a response. Curtis had received the letter. The HOA's management company had logged it in August 2021. The log entry appearing in the management company's records that Thomas had obtained through a public records request for all correspondence between the HOA and adjacent property owners. The log entry read, August 16, 2021. Letter received from Nora Crane, Western Shore adjacent parcel, easement claim on construction. Forwarded to President. There was no response entry, no letter back to Nora, no note in the file indicating that Curtis had asked Brenda to review the easement claim, no record of any action taken in response to a letter that had told the HOA in August 2021 that the easement existed and the construction was encroaching on it. Thomas had written, in August 2021, the easement holder sent a written notice to the HOA president identifying the 1962 easement instrument, describing its corridor location, and stating that the HOA's construction activity appeared to include structures within the easement corridor. The HOA received this notice. It is logged in the management company's correspondence records. The HOA took no action in response to the notice. The HOA continued construction within the easement corridor for the remaining months of the construction schedule. The HOA then proceeded to market, pre-sell, and schedule closings for 31 cabin units, whose primary amenity infrastructure was constructed within an easement corridor that the HOA had been put on written notice of in August 2021. The abandonment doctrine cannot be applied to benefit a party that received written notice of an easement during construction, chose not to investigate or respond to that notice, and proceeded to construct prohibited structures and market them as private amenities. The equitable dimension of the abandonment doctrine, which requires that the party asserting abandonment have acted in reasonable reliance on the abandonment, is simply unavailable here. He had attached the management company's correspondence log as Exhibit F and the 2021 notice letter as Exhibit E, and had cited both in the rebuttal brief's conclusion. The HOA had written notice of the 1962 easement in August 2021. The HOA chose not to respond to that notice. The HOA proceeded to complete construction, market the cabins, pre-sell 31 units, and schedule closings, all with the August 2021 letter in its management files. The abandonment theory asks this court to extinguish a recorded easement held by a party who used it annually, asserted it in public planning proceedings, and sent written notice of it to the HOA during construction. This court cannot grant that relief. Brenda had read Thomas's rebuttal on a Thursday afternoon and had called Curtis that evening. She had said, the 2021 letter. Curtis had said, I forwarded it to the management company. She had said, and then what? He had said, I assumed it was a neighbor making noise. We were 8 months into construction. I didn't think it was a serious legal claim. Brenda had been quiet for a moment. She had said, it was a serious legal claim. It was a licensed title examiner and the holder of a recorded easement telling you in writing that your construction was encroaching on her corridor. It is now in Thomas Vale's rebuttal brief as the document that destroys the equitable reliance argument for abandonment. We told the court the HOA relied in good faith on the belief that the easement was abandoned. Thomas just put in writing that the HOA had notice of the easement during construction and chose not to investigate it. Curtis had said, can we respond to that? She had said, I can file a reply brief. I cannot undo the fact that the management company logged the letter in August 2021 and the HOA did not respond to it. That log entry is in the public records. The judge is going to read it. He had said, file the quiet title action. She had said, Curtis, the rebuttal brief is strong, The 2021 letter makes the equitable reliance argument unavailable, and the Affirmative Act requirement makes the legal abandonment argument very difficult. I'm not telling you we cannot file the quiet title action. I'm telling you the probability of success is low. He had said, "File it anyway. All 31 closings are suspended. I have 31 buyers with deposits paid and closing dates that have passed, and attorneys sending me demand letters. I need the court to either extinguish the easement or force a resolution. File the quiet title action." She had filed it the following Monday, a complaint to quiet title, seeking a court declaration that Instrument 1962-04-0847 had been abandoned and was extinguished, and that the Western Bank parcel's lakefront amenity infrastructure was free of the easement's restrictions. The title company had notified all 31 buyers that their closings were suspended pending the quiet title proceedings resolution. The buyers had notified their lenders. The lenders had notified the title insurance underwriter. The underwriter's regional counsel had begun an internal review of the title commitment's failure to disclose the 1962 instrument. 31 buyers had signed purchase agreements between $180,000 and $240,000 for cabin units whose primary amenity was suspended. Their deposits were held in escrow. Their closing dates had passed. Their attorneys were drafting letters. The quiet title proceeding was on the court's docket. Nora Crane had a property log with 8 years of annual corridor walk entries, a 2018 Planning Commission letter, and a 2021 notice letter that the HOA had logged, filed, and not answered. She had walked the corridor in October 2021, knowing the quiet title action was the next step. She had documented the walk. She had noted the dock pilings. She had noted the beach grading. She had noted easement, active and maintained. She had closed the log. The court had the file. The 2021 letter was Exhibit E. The quiet title hearing had been set for a Thursday morning in September. Courtroom 3, County District Court, Judge Patricia Odom presiding. Judge Odom had been on the property and probate docket for 9 years. Before the bench, she had practiced title law for 6 years, chain of title work, quiet title actions, easement disputes, the full range of recorded instrument litigation that property law produces in a county where land has been passing through families for generations. Her background was the specific expertise that made her assignment to this matter either fortunate or unfortunate, depending on which side of the counsel table you occupied. Brenda Polk had noted the assignment and had called Curtis. He had asked, "Is that good for us?" She had said, "It means she will read the 1962 instrument the way it was written and will not need either party to explain what a recorded easement is." He had said, "And." She had not answered the "and." Brenda had presented for 40 minutes. She had opened with the 31 buyers, the framing device that put the court's sympathies in the most useful place, before the legal doctrine was addressed. 31 families had purchased cabin units in good faith, deposits in escrow, lenders in process, closings suspended. The buyers had no role in the title search failure. The relief the court could provide, a declaration that the 1962 easement was abandoned and extinguished, served their reliance interests, and resolved a title encumbrance created by a 60-year-old instrument whose original public purpose had been overtaken by the development it was designed to serve. She had moved to the abandonment theory, the constructive abandonment doctrine, the railroad right-of-way case, the 4 resident declarations attesting to minimal public use of the corridor across decades, the aerial photograph sequence from 1975 through 2014, showing the western shoreline's undisturbed vegetation and the absence of any worn footpath indicating regular public pedestrian traffic. She had said, "The 1962 corridor was created for public pedestrian access along a lakeshore that had no residential development on it at the time. 60 years later, the development exists. The public access purpose has been dormant for the entirety of the easement's recorded existence. The changed conditions and the practical obsolescence of the original purpose collectively constitute the constructive abandonment the doctrine recognizes." She had addressed the equitable estoppel argument last, Nora's silence at the Planning Commission hearing in April 2020, her silence through 2 years of visible construction, her failure to seek injunctive relief while the dock pilings were being set, and the beach was being graded. The HOA had proceeded in reasonable reliance on the belief that the corridor would not be enforced. The construction had been completed. $6 million of cabin units had been pre-sold. The equitable dimension of the abandonment doctrine protected parties who had built in good faith. Thomas had taken 35 minutes. He had opened with the legal standard and had addressed it to Judge Odom directly, not as a restatement of the brief, but as the precise question the hearing needed to answer. He had said, "The abandonment doctrine in this state requires affirmative acts by the easement holder, demonstrating a clear and unequivocal intent to permanently relinquish the right. This standard has been stated consistently for 60 years. It has never been modified to allow non-use, however extended, to substitute for affirmative relinquishment. The HOA's constructive abandonment theory asks this court to become the first court in this state to extinguish a recorded easement on the basis of non-use alone." He had distinguished the railroad case in 3 minutes, the ICC filing as the affirmative act, the non-use as corroborating circumstance, the decision's own language making the distinction explicit. He had said, "The railroad case supports the proposition that an affirmative act of relinquishment, combined with extended non-use, can establish abandonment. It does not support the proposition that non-use alone is sufficient. There is no affirmative act in this record." He had presented Nora's use documentation, the property log extracts, 8 consecutive years of annual corridor walks from 2014 through 2021, each dated, each contemporaneously recorded. He had said, "The easement holder has walked this corridor annually for 8 years for the purpose the instrument describes, pedestrian access along the western shoreline. The public access purpose is not obsolete. A person has used this corridor every year. That person is the easement holder, and the instrument authorizes exactly that use." He had addressed the public policy argument with the directness of an attorney who recognized its rhetorical weight and needed to remove it before the legal argument completed. He had said, "The 31 buyer's sympathetic position is the result of 2 decisions made by the HOA. The decision to acquire a lakefront parcel without a title search that would have found a recorded instrument in 20 minutes, and the decision to ignore a written notice received during construction that told the HOA the encroachment existed. The buyers have title insurance policies that insure against exactly this undisclosed encumbrance. Their remedy exists. It does not require this court to extinguish a valid recorded instrument." He had set the 2021 notice letter on the podium and addressed equitable estoppel. He had said, "The equitable estoppel doctrine requires reasonable reliance without knowledge of the true facts. In August 2021, the easement holder sent a written notice to the HOA president identifying the 1962 instrument by number, describing the corridor's location, and stating that the HOA's construction appeared to include structures within the corridor. The HOA's management company logged the letter. The management company's log entry reads, "Letter received from Nora Crane, Western Shore adjacent parcel, easement claim on construction. Forwarded to President. The HOA took no action. The HOA completed the construction. The HOA pre-sold 31 units and scheduled closings. With this letter in the management files the entire time." The equitable estoppel argument is not available to a party that had written notice of the claim and chose not to investigate it. He had sat down. Judge Odom had looked at her notes and had said, "Ms. Polk, I have a question about the abandonment theory." Brenda had stood. Judge Odom had said, "The abandonment doctrine requires affirmative acts by the easement holder, demonstrating intent to permanently relinquish. Mr. Vale argues no affirmative acts exist here. I want to ask you directly, what affirmative act by Nora Crane or Arthur Crane before her demonstrates a clear intent to permanently relinquish instrument 1962-04-0847? The courtroom had been quiet for a moment. Brenda had said, "The affirmative acts in this case are constructive rather than express. The totality of circumstances, including the 60-year absence of public use, the changed conditions of the surrounding area, and the practical obsolescence of the public access purpose, collectively constitute the affirmative demonstration the doctrine requires." Judge Odom had said, "That is a restatement of the constructive abandonment theory. I'm asking about affirmative acts. What did the easement holder do that affirmatively demonstrated intent to permanently give up this right? Brenda had said, the failure to enforce the easement's restrictions during construction, the decision not to appear at the permit hearing, not to seek injunctive relief, represents an affirmative choice to allow the development to proceed without invoking the restriction. Judge Odom had said, the failure to enforce a right is not an affirmative act of relinquishment. Can you cite a case in this state where a court found easement abandonment based on the easement holder's failure to enforce rather than on an affirmative act of relinquishment? Brenda had looked at her legal pad. She had started to reference the railroad case and had stopped. She had said, I am not aware of a case in this state that found abandonment on the basis of non-enforcement alone, Your Honor. Judge Odom had written something and had said, thank you, ruling within 10 days. The ruling had arrived on a Wednesday morning, 6 pages. The analysis had moved to its conclusion without extended development, because the legal question, once the affirmative act requirement was applied to the undisputed facts, resolved itself quickly. Judge Odom had written, the abandonment doctrine requires affirmative acts demonstrating a clear and unequivocal intent to permanently relinquish the easement right. The plaintiff has not identified any such act. The easement holder's annual documented use of the corridor, her 2018 letter to the County Planning Commission, and her August 2021 notice letter to the HOA president collectively demonstrate the opposite of abandonment intent. An easement holder who was actively aware of the instrument, actively using the corridor, and actively notifying the HOA of the encroachment during construction. The quiet title action is denied. Instrument 1962-04-0847 is a valid and enforceable recorded easement. The public policy argument had received 1 paragraph. The court is sympathetic to the 31 cabin buyers. Their remedy lies with the parties responsible for the title commitment's failure to disclose the recorded encumbrance, not with the extinguishment of a valid instrument held by a party who gave written notice of the encroachment during construction. The equitable estoppel argument had received 2 sentences. Equitable estoppel requires reasonable reliance without knowledge of the true facts. The HOA received written notice of the 1962 easement in August 2021 and took no action. The estoppel argument is unavailable. Brenda had called Curtis at 8:50 a.m. She had said, the quiet title action was denied. The easement stands. Judge Odom asked me in the hearing what affirmative act demonstrated abandonment intent, and I could not identify one. The ruling reflects that. Curtis had said, all 31 closings are still suspended. She had said, yes, the litigation path is exhausted. The abandonment theory failed. The equitable estoppel theory failed. And an appeal would require identifying a legal error in Judge Odom's application of the affirmative act standard, which is the correct standard and which she applied correctly. The only path to reopening the closings is a negotiated resolution with Nora Crane. He had said nothing. She had said, the terms from Thomas Vale's May demand letter are still on the table. They may be worse now than they were in May. 4 months of suspended closings, 31 buyers with attorneys billing weekly, a failed quiet title action in the record, and a title insurance underwriter conducting an internal review of the commitment failure. The longer this stays unresolved, the more each additional day costs. Curtis had said, call him. He had set the phone down and had sat at his desk, the lake visible through the window, the Western Shore's cabin structures in the September light, the dock piling standing in the corridor that a county district judge had just confirmed was valid and enforceable. He had looked at the lake for a long time. Then he had picked up his phone and had called Thomas Vale himself, not routing through Brenda, not drafting a letter, the direct call of a man who had run out of positions. Thomas had answered on the second ring. Curtis had said, Mr. Vale, Curtis Halford, I've read the ruling. I want to discuss resolution. Thomas had said, Ms. Crane has been available for that conversation since May. Call me tomorrow morning. The call had lasted 70 seconds. Outside the window, the lake sat still in the September afternoon. The 40-foot corridor running along the western shore from Arthur Crane's 1962 survey line to the ordinary high water mark. Unextinguished, unmodified, exactly as recorded on April 14, 1962, waiting for tomorrow morning. Thomas had the terms outline ready when Curtis called Friday morning. 4 points, the same framework Nora had approved in the week after the quiet title ruling, presented without preamble because Curtis Halford had called, having read Judge Odom's ruling, and there was nothing left to establish before the numbers. The first point, a recorded modification of the 1962 easement instrument, converting the public access corridor from a general public pedestrian easement to a private shared-use easement appurtenant to 2 parcels jointly, Nora's Western Shore parcel and the HOA's Western Bank Cabin parcel. The modification would preserve the corridor's physical dimensions and its prohibition on structures obstructing pedestrian passage, but would narrow the beneficiary class from the general public to the 2 adjacent parcel owners and their successors and assigns. The HOA's 31 cabin unit owners would have documented shoreline access rights through the shared-use easement appurtenant to the HOA's common area parcel. Nora would retain her annual corridor access with the added protection of the shared-use instrument's maintenance provisions. The second point, a permanent recorded acknowledgement of the 1962 instrument's priority, a document stating in recorded language that Instrument 1962-04-0847 predated and held priority over all subsequent development on the Western Bank parcel, that the HOA's cabin development had been constructed with notice of the easement's existence, as established by the August 2021 correspondence, and that the shared-use modification did not diminish or waive the 1962 instrument's original legal force. The acknowledgement would run with both parcels, and would appear in every future title search conducted on the HOA's cabin units, a permanent record that the Shoreline's legal history began with Arthur Crane's 1962 recording, not with the HOA's 2019 acquisition. The third point, a conservation restriction recorded against the HOA's Western Bank parcel, prohibiting any structure within 15 feet of Caldwell Lake's ordinary high water mark in perpetuity. The restriction would be appurtenant to Nora's parcel as the benefited property, enforceable by Nora and her successors and assigns against any future owner of the cabin parcel. The existing dock approach's encroachment within the 15-foot zone would be grandfathered under a specific exception, but no additional structure of any kind, dock, pavilion, seawall, retaining wall, or any other construction, could be placed within 15 feet of the ordinary high water mark without Nora's written consent. The fourth point, the settlement payment. Thomas had calculated 3 components: the encroachment compensation, covering the period from the start of construction in fall 2020 through the settlement date, a per diem figure for each day a prohibited structure had existed within the easement corridor, Nora's legal costs for the full proceeding from the May demand letter through the quiet title ruling, and a recorded instrument fee covering the title examination work Thomas had engaged Nora to perform in her professional capacity as a licensed title examiner in connection with the encumbrance certificate and the closing day presentation. Curtis had listened to all 4 points without interrupting. When Thomas finished, he had said, "The conservation restriction, 15 feet, is more restrictive than the existing dock approach location." Thomas had said, "The existing dock approach is grandfathered. The restriction governs future construction. The dock approach you built is within the grandfathered exception. Nothing new goes within 15 feet without Ms. Crane's consent." Curtis had said, "And the 31 buyers' closings." Thomas had said, "The modification and the acknowledgement record first." The title company reissues the commitment for each unit with the shared use easement disclosed in Schedule B. The closings proceed on the corrected commitment. Each buyer receives clear title to a cabin unit with documented shoreline access through the shared use easement. Curtis had said, "The underwriter." Thomas had said, "I filed a formal claim against the 2019 title commitment on behalf of Ms. Crane last week. The underwriter's regional counsel has been in contact. The underwriter has exposure on 31 policies for the undisclosed encumbrance and additional exposure on the claim I filed. The underwriter's contribution to the settlement payment will be negotiated separately between the underwriter and the HOA under the indemnification provisions of the development's title insurance agreement. That negotiation is between you and the underwriter. Ms. Crane's settlement payment comes from the HOA. How the HOA recovers a portion of it from the underwriter is your arrangement to make." The negotiation had taken 3 weeks. 2 sessions with Thomas and Carol Vreeland, the property attorney the HOA had retained after the quiet title ruling to handle the settlement instruments, Brenda Polk having stepped back from the matter by mutual agreement after the hearing. The first session had resolved the easement modifications language and the conservation restrictions scope. The second session had resolved the settlement payment, the encroachment compensation figure, the legal costs, the title examination fee. The final number reached in the session's last 30 minutes after Carol worked within a board-authorized range, and Thomas held Nora's floor through 2 intermediate positions. The Underwriters Regional Council had called Thomas the week after the second session and had settled the formal claim in a separate negotiation that took 4 days, the underwriter acknowledging the commitment failure, contributing a specific sum toward the HOA's settlement payment obligation, and reissuing the title commitments for all 31 units, with the shared use easement disclosed in Schedule B at no additional premium to the buyers. The instruments had been executed at the county recorder's office on a Monday morning. Thomas and Carol at the recorder's counter, the modification of easement first, the recorded acknowledgement second, the conservation restriction third. Each instrument assigned its own number, each recorded against the appropriate parcels, the modification cross-referenced to the original 1962 instrument number in the recording notation. The settlement payment had cleared escrow the same morning. Thomas had called Nora from the recorder's parking lot at 10:45 a.m. He had said, 3 instruments recorded, payment cleared. I'll send you the confirmed instrument numbers when the recorder's confirmation comes through this afternoon. She had said, the title company. He had said, Sandra Reeves' office reissues the corrected commitments this week. The schedule shows the first corrected closing next Tuesday. All 31 units close on the corrected commitment with the shared use easement in Schedule B. She had said, the conservation restriction. He had said, recorded as Instrument 3, appurtenant to your parcel, running with the HOA's cabin parcel in perpetuity, 15 feet from the ordinary high water mark. Nothing new goes in without your written consent. She had said, Arthur would have added the 15 feet himself if he'd thought of it in 1962. Thomas had said, he thought of the 40 feet. That was enough to make this work. She had said, it was. She had set the phone down and had looked out the window at the lake. The October morning clear, the western shore's willows beginning to turn, the cabin structures visible to the north, with their completed decks and their dock approach pilings standing in the shallows, within the corridor that was now a shared use easement, recorded in the county deed records, with 3 new instrument numbers, cross-referenced to the original 1962 filing. Arthur had recorded 1 instrument on April 14, 1962. 60 years later, it had produced 3 more: the modification, the acknowledgement, the conservation restriction, each one running with the land, each one in the county deed records, each one adding to the legal history of a shoreline that Arthur Crane had understood was worth protecting carefully when he platted the lake the year Nora turned 8. She put on her jacket and went to walk the corridor. Nora had walked the corridor at 7 a.m., the October morning cold and still, the frost on the sedge grass along the inland boundary catching the early light, the lake surface flat and gray in the calm before the wind came up. She had started at the northern boundary marker, the iron pin her grandfather's survey firm had set in 1962, still in the ground 62 years later, the cap stamped with the survey firm's name and the year. She had touched the cap with 2 fingers the way she did every year at the start of the walk, and had turned south, the lake on her left, the 40-foot corridor opening before her along the western shore. The cabin structures were visible to the north, the completed units on the HOA's parcel, the decks extending toward the water, the dock approach pilings standing in the shallows at the corridor's edge. The pilings were grandfathered now, the conservation restrictions specific exception, the existing encroachment acknowledged and bounded, nothing additional permitted within 15 feet of the ordinary high water mark without her written consent. The pilings would stand where they stood. No new pilings would join them. She had walked the full length in 20 minutes, north boundary to south boundary, the same route she had walked every year since 2014, the same route that had appeared in her property log 8 times before this morning, and would appear a 9th time before the day was done. The corridor was unchanged from last October's walk in every physical respect. The same willow roots at the waterline, the same bedrock outcrop at the corridor's midpoint where the shore curved slightly east, the same sightline across the lake to the eastern development that Arthur had platted in 1962, on the proceeds of selling 87 lots to people who wanted to live beside the water he had grown up beside. At the southern boundary, she had stopped and looked back north along the corridor's length. The 40 feet of shore her grandfather had measured and recorded as a public access strip, when the western bank had been nothing but willows and sedgegrass and the sound of the lake. The county deed records now showed 4 instruments on this corridor: the original 1962 easement, the modification, the acknowledgement of priority, the conservation restriction. The Shoreline had more legal history attached to it this morning than it had carried at any point in its recorded existence. She had opened her property log at the southern boundary marker and had written the final entry standing in the October morning with the lake at her left shoulder. October 2022. Corridor walk, full length north to south. Conditions: clear, frost, lake calm. Easement modification recorded October 17th, 2022. Instrument number confirmed. Acknowledgement of priority recorded. Conservation restriction recorded. Appurtenant to Western Shore parcel. 31 cabin closings proceeding on corrected title commitments. Shared use easement disclosed in Schedule B. Corridor clear. No new obstructions. Instrument 1962-04-0847. Active, modified, and recorded correctly. Matter recorded. She closed the log and held it for a moment. The same log she had opened in March 2021 when she called Thomas Vale. The same log that had held 8 years of annual corridor walk entries, and the closing day notation, and the quiet title ruling date. The log that had been, in Exhibit C of Thomas's rebuttal brief, the documented proof that the easement had never been abandoned. Arthur had kept his documents in labeled folders in an organized filing cabinet. She kept hers in a dated log in a waterproof field notebook. Same discipline, different generation, same result. She walked back along the corridor to the house, the lake behind her, the frost beginning to lift off the sedge grass in the morning's first warmth.